We're going to begin with the race for the North Carolina Supreme Court. And so our first candidate who will be coming up here is Superior Court Judge Mike Morgan, who is Superior Court Judge in District 10B in Wake County. So Judge Morgan. Welcome.
Thank you and good morning. My name is Judge Mike Morgan, and I'm currently a Superior Court Judge elected in Wake County, and I am running for the North Carolina Supreme Court. I'm running on the strength of 27 years of experience on the bench here in North Carolina, 11 and a half current years as a Superior Court Judge, 10 and a half years prior to that as a District Court Judge, and 5 years prior to that as a State Administrative Law Judge. So 27 years altogether, covering 3 judgeships as I continue to elevate towards the North Carolina Supreme Court. In addition to being one who has been in the courtroom, however, I've also been in the judicial classroom. I teach judges out at the National Judicial College, being on their faculty. I've been doing that for 24 consecutive years now. In doing that, I've been teaching judges from across the country how to be better judges. And that esteemed institution rewarded me last year for that service by having its president come all the way to North Carolina, cross country, at the North Carolina Bar Association's meeting last year in Asheville, and gave me their coveted V. Robert Payon Award for Teaching Excellence, emblematic of being their National Teacher of the Year. In addition to that, though, there's not just the opportunity to be in the courtroom and in the classroom in terms of judicial education, but also getting out in the community, being on the grassroots level. And that's what I feel gives me a very special skill set, because I go out in the community, I've always been in the community, and do what I can to uplift the community in terms of making myself available to educate and to demystify the processes in terms of making sure that people understand that our legal system indeed is above reproach and certainly is one to be commended and observed. As far as this question about judicial activism is concerned, I do not believe that a judge should practice judicial activism. The law is made by the legislature, and it is up to judges to apply and interpret the law as it is deemed to be. Where we have had progress in our society in terms of some very meaningful, monumental legal changes in terms of the case law, that has not come from judges being ones that practice judicial activism, but it's been those that have looked at the Constitution and applied constitutional principles to our society as our society continues to evolve and to progress. And so in that sense, we don't have to look to judges to be activists. As a matter of fact, it's a curious situation. When you elect a judge, or otherwise when a judge is appointed, you get that judge and that judge's personality. And in getting that judge's personality, a judge can't change who he or she is. We are who we are based upon whatever our upbringing may be, our environment may be, and how that operates upon us. But in terms of going beyond who we are and then putting on a layer of our personal activism by way of judicial activism, what we're doing then is doubling down on who we are inherently in terms of exercising discretion as we can in certain judicial situations. And at that point, you're doing more in terms of articulating some personal opinion or some personal proclivity, which ought not be done. In that sense, it's kind of like having a peanut butter sandwich. It's okay to be who you are on the inside and like what it is on the inside, but when you slap on an extra layer of peanut butter and jelly on the outside, you've got more than you need to have. Also, that makes for a messy situation. And in that sense, if you're messy in terms of putting too much of your personal self into your judiciary, that's when you begin to have problems. And that also involves political biases. It just so happens that my opponent puts on his yard signs and his other materials that kind of political leaning or political proclivity that one ought not to have. We are, again, who we are by way of our environment and by the way of our personal interests, but when you slap on an extra layer, you're doubling down in a way that is certainly inappropriate. I believe in the separation of powers, and I know my opponent believes in separation of powers because he talks about it. But I'll go a step further. He talked about it in his re-election campaign on March 1st, 2008 while he was campaigning in Boone, North Carolina, and he said the following statement about his candidacy, quote, "I am the one person who is standing between you and one-party government in North Carolina," unquote. Surely he hasn't felt a different way now that the party to which he happens to belong is in power. I believe certainly that he would still believe that it should be a situation where the one who is the one party standing between one and one-party government should not be in place. I'm in the situation that he was in 8 years ago. I'm the one person standing between you and one-party government in North Carolina. And just as my opponent felt about it when it operated in his way in 2008, I encourage you to follow the philosophy he articulated and apply it here in 2016 as it now favors me. Judge Mike Morgan for the North Carolina Supreme Court. Thank you.
Thank you very much, Judge Morgan, and I neglected to give you his question. Each of the candidates has a different question. So very briefly, his question was, Black's Law Dictionary defines judicial activism as a philosophy of judicial decision-making whereby judges allow their personal views about public policy, among other factors, to guide their decisions. Do you believe there are times when it is appropriate for a judge to incorporate his personal views on issues to guide his decisions? So that was the question that he was responding to. Next, we will hear from current Supreme Court Justice Robert Edmunds. Let me give you his question that he is responding to. As we all know, our government is comprised of three branches: executive, judicial, and legislative. When legislative matters are before the court, do you have a personal philosophy as to what degree of deference, if any, should be given to laws enacted by the General Assembly? When administrative matters are before the court, what degree of deference should be given to executive branch officials? So, Justice Edmunds.
Thank you, David, and good morning, everybody. And my thanks to the North Carolina Association of Defense Attorneys for this invitation. It's great to be back among so many friends. I apologize that I'm going to have to sprint out of here as soon as this segment is over. I'm speaking at a CLE in Cary on appellate practice. But in accordance with the instructions, I will start by speaking about my candidacy. I'm running on the basis of my record and my experience. Now, Oliver Wendell Holmes, everybody's favorite Supreme Court justice, said, "The life of the law has not been logic, it has been experience." So what is important for a position on the court of last resort is not the mere accretion of experience that comes with years. What is important is pertinent experience, the experience that informs the work of a justice. I've been on the Supreme Court for 16 years. You elected me in 2000 and re-elected me in 2008. And I suggest that the strongest factor in deciding whether someone is the best candidate for the North Carolina Supreme Court is whether they've already shown they can do the job. My record is an open book. All my opinions are available online. And I believe those opinions show a justice who has established a record of being fair, being independent, of being nonpartisan, and a record of integrity. But you don't have to take my word for it. You can check out my website, and you'll see that I've been endorsed by 4 former Chief Justices of the Supreme Court, 2 Republicans, 2 Democrats. I've been endorsed by most of the former presidents of the State Bar and of the North Carolina Bar Association. These are the men and women who are most directly affected by my work. They have reason to know its quality, and they're not easily fooled. Looking out of state, last month I was named the chair-elect of the Appellate Judges Conference of the American Bar Association, a group of over 1,100 state and federal appellate judges and practitioners. Now, I told them I had an election. Anything could happen, but they said, "We know your work. We'd like for you to do the job." Another pertinent experience has been my years in private practice. I'm the only candidate who's done what you do. I know if you don't produce in private practice, you don't get paid. I know what it's like to work with difficult clients, difficult opposing counsel. I know what it's like to work with difficult judges. But when I left private practice, I was board certified in state and federal criminal law. I was board certified in appellate practice, and I had Martindale's highest rating. Before private practice, I was the U.S. Attorney for the Middle District of North Carolina, appointed by the President of the United States. So I think I have the type of experience that Holmes was talking about. Now, turning to the question that was posed, I'll start by saying that my judicial philosophy is fairly easy to state, and I will point out that my opponent continues to confuse political conservatism with judicial conservatism. I'm a judicial conservative. I believe do no harm. I believe in honor the rule of law. I believe in understanding the separation of powers, and I believe in the respect for precedent. So the question that was posed that David just read comes under the separation of powers components. As for acts that have been passed by the General Assembly, the jurisprudence is pretty well established, and there's little room for individual philosophy. An act passed by the General Assembly, there's a strong presumption that such a bill is constitutional. But that said, the Court is mindful of its responsibilities on occasion to be the referee between the executive and the legislative branches of judgment. And where necessary, the Court has been perfectly willing to declare statutes unconstitutional. Some in the last couple of years have included the teacher tenure case, which I wrote, the MAP Act case, the Coal Ash Commission, which was a direct conflict between the executive and the legislative, and one Dixie mentioned, the cyberbullying case. Now, as to the executive branch, the law is a little more nuanced. When an agency construes a statute, we review that statute, that interpretation de novo, but we do grant the agency some deference in its interpretation. In other words, we take a close look, but doing so with the understanding that the agency usually has expertise and experience in the field. And if the Court determines that the statute gives the agency the power to act, we don't consider the wisdom of the agency decision. But if the agency is not looking at a statute, but is instead interpreting its own rules and regulations, the Court gives substantial deference to the agency's decisions. And lastly, when reviewing an agency's final decision in a contested case, we review the questions of law de novo and apply the whole record test to questions of fact. As a believer in the rule of law and the importance of precedent, my philosophy is to follow the procedures I've outlined, like I've been doing for the last 16 years. I would appreciate your vote. Thank you very much.
Thank you, Justice Edmunds.